So the DOJ and AG Bondi recently joined the fight against statewide concealed carry ban laws, which are currently in front of the Supreme Court. The state of Hawaii has now filed their response to that, and they argue that the Supreme Court should not review this, and they're also not happy that the federal government in the Trump administration stepped in this case. So let's talk about what just happened. As I mentioned in the intro, in this video, I have an important update for you and everyone kind of in states like New York, California, Hawaii, and other states who are currently facing attempts to ban concealed carry. You may recall that recently the Ninth Circuit issued some decisions in multiple concealed carry cases dealing with states passing these response bills to Bruin and trying to ban concealed carry within states. One of these was the California SB2 lawsuit and the other was the Hawaii concealed carry ban. The case which is currently seeking Supreme Court review is the Hawaii Wolford versus Lopez case. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states' catch-all public property bans are in fact permissible under the Second Amendment. Recently, to the surprise of many, the DOJ and AG Bondi and the Trump administration stepped up in this lawsuit and they pushed for the Supreme Court to actually review this case on an emergency basis. They said that it was finally time for the Supreme Court to review this issue of carry bans once again and look at what these lower courts were doing as far as defying Bruin. They also asked the Supreme Court to review some other issues, and they had mentions of rifle bans and magazine bans. Of course, this was good news because you had the DOJ jumping in, finally supporting the pro-2A side. However, the state of Hawaii has now filed their response to the Supreme Court, and they're not happy about what's going on. And they essentially said that the DOJ and the Trump administration were uninvited guests, and the Supreme Court should ignore what they said. Now, this case is a challenge to Hawaii's new laws on concealed carry that they passed in response to Bruin. This law, like others, tried to add in more restrictions of concealed carry and create kind of a default rule where individuals can carry firearms on private property only if the owner of the property provides express permission to do so. This also applied to public property or property that was open to the public. Think of things like Walmart, Target, and other stores. They would have to put out a sign or tell you expressly that you could conceal carry at that location. This law also sought to operate in a way where even if you got a permit under the hyper-restrictive permit process in the state of Hawaii, your permit was almost useless because you could not carry anywhere lawfully. And this was all done in direct response to Bruin, and this was because Bruin got rid of May issue schemes. Hawaii already had a very bad permits process before Bruin. There was some 2018 reports by the Ninth Circuit where only 4 concealed carry licenses had ever been issued to private citizens in the state of Hawaii over the last 18 years, and one county had not ever even issued a single license ever. However, like I mentioned in Bruin, they said that these type of May issue schemes were impermissible, that individuals had a right to concealed carry out in public. You had a right to concealed carry outside of your home, and that May issue schemes and this discretionary process that was put in place was in fact unlawful and violated the Second Amendment. Hawaii responded to Bruin by passing Act 52 like other states did. They tried to pass laws that overhauled their carry process, but still made it even worse than the one that existed prior. In response to that, plaintiffs sued the state of Hawaii, and they were joined by multiple organizations. They did end up getting a temporary restraining order by a lower court, which was later converted into a preliminary injunction. Now, in that decision, the district court blocked the private property rule as likely a violation of the Second Amendment and inconsistent with Bruin. This case made its way eventually to the Ninth Circuit because Hawaii did not like that TRO and that preliminary injunction, so they appealed to the Ninth Circuit. However, on review, the Ninth Circuit upheld this whole catch-all property ban that was put in place by the state of Hawaii. The Ninth Circuit relied on older restrictions on hunting on private property and then also some old racist laws. They relied heavily on those to justify what they did in their decision. Now, what happened after that is the plaintiffs sought en banc panel review in the Ninth Circuit. However, that was denied. But you did have some judges on the Ninth Circuit en banc panel, like Judge Van Dyke and others, who said that it was improper for the Ninth Circuit to not review what happened at the 3-judge panel level in the Ninth Circuit. But that was kind of beside the point because we knew how the Ninth Circuit was ultimately going to rule on this issue. And that then led this case to go to the Supreme Court once again, and it's in front of the Supreme Court seeking emergency review. The question presented to the Supreme Court for review is whether the Second Amendment allows a state to make it unlawful for concealed carry license holders to carry firearms on private property open to the public without the property owner's express authorization. Now, this case theoretically kind of had a long shot of getting Supreme Court review since it was still in an interlocutory review. It was dealing with a preliminary injunction, and the Supreme Court just categorically and generally does not like these type of interlocutory cases, especially when it comes to two-way cases. However, now you have the United States government, the AG's office, the DOJ, the Trump administration, who jumped in support of this challenge, saying the Supreme Court should grant review to this case right here and now. In the recent Amicus brief by the U.S. government, they stated that near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary law-abiding citizen has a general right to publicly carry arms for self-defense. Here, the federal government is pointing out that the historical justifications used by the Ninth Circuit to uphold this catch-all property ban should have been found insufficient, but the Ninth Circuit twisted things as they always do to uphold this type of restriction. One of the interesting things with this brief is that the federal government pushes the Supreme Court to also take this case at an interlocutory posture, review the preliminary injunction despite the court's track record of avoiding those types of issues. The government also snuck in a quick mention about the Supreme Court needing to address rifle bans and magazine bans, but that's not super relevant for this specific lawsuit. Now, recently the state of Hawaii filed a reply to this petition, and they're arguing the Supreme Court should not review this case. It's still too early for case review here, that it's dealing with a preliminary injunction. The record has not been fully developed. There's not enough, arguments or briefs on these issues. And also, there's no circuit split yet on this issue of public carry bans. So essentially, at this point, they're saying that the Supreme Court should simply just punt this issue like they did other two-way cases. They also try to push back against the Trump administration stepping in to support review of this case right now. In the brief, Hawaii argues that the United States' uninvited amicus brief does not change the calculus. The United States asserts that the court should grant certiorari with respect to the first question presented because the Court of Appeals erred in upholding the default rule's constitutionality. And then they note the United States says nothing about the second question presented, which speaks volumes. Now, that's interesting because on the one hand, you have the state of Hawaii saying that the U.S. brief was uninvited, it should be ignored. But then on the other hand, they're saying, well, the U.S. government didn't address this one question presented on the petition, and that tells a lot that should be persuasive for why this type of restriction should be upheld. So this brief by the state of Hawaii really struggles to get over a lot of the arguments raised by the plaintiffs on their petition. And essentially, Hawaii tries to dismiss what the U.S. government said in their amicus brief by calling them an uninvited guest. But that's kind of exactly what an amicus brief actually is in essence. It's a third party jumping in to file additional arguments to assist the Supreme Court in their determination of whether or not they're going to grant review to the case or ultimately help them determine how they're going to rule in the lawsuit. Also, anti-gunners seem to never have any issues when it was the Biden administration jumping in to help, protect their anti-gun laws. However, now that it's the other way and you have the federal government and the Trump administration trying to support the pro-2A side, all of a sudden they're uninvited guests, they should be dismissed, and their arguments are unpersuasive. Ultimately, you still need the Supreme Court votes to grant review to this case. However, I think this is in a better position. There's still the looming question of if they're even going to want to take this on an interlocutory posture. The general sentiment of the Supreme Court is that they've avoided these types of interlocutory two-way cases. They've punted a lot of issues recently. They punted the rifle and magazine ban cases. So it's unseen right now whether or not the Supreme Court wants to take any more two-way cases or if they're going to continue to punt them. And one of the easy ways to punt this specific lawsuit is say that it's still dealing with a preliminary injunction. It's an interlocutory posture. We don't need to review this right now. We're going to let the lower court further develop this and issue a final merits decision. So we're going to see how this plays out. But good news that the Trump administration stepped in support of this lawsuit. The state of Hawaii is trying to dismiss that by calling them an uninvited guest. But I don't think that's going to be persuasive. I think the DOJ's arguments are going to be factored in somewhat because they do carry some weight about how the current administration is dealing with these types of issues. So as we get more information, as this develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.